Welcome everybody to another I don't know what's gonna happen in the courtroom episode of Lockdown 23 and 1. That's right, we're jumping back into the courtroom once again with your Honorable Judge Boyd. And the individual going in front of her is going to be very confused as to what he should do. The defendant has a plea deal, but if he doesn't take it, he could be facing up to 25 years in prison as a habitual offender. Not to mention, he's not happy with his attorney, not one bit. And I'm here to tell you what you're about to see is a typical process inside the courtroom. A lot of defendants go into courtroom with a game plan. As soon as they get in there, they realize very quickly it should never have been in the playbook to begin with. So let's get into it, ladies and gentlemen. If you enjoy all things lockup and crime related, then this is where you want to be. Hit that like, subscribe, notification bell before you leave, and check out my playlist with many more videos for you to start watching today.
Mr. Saldana, you're here for a plea deadline date. So did you have a chance to internalize what I was telling you?
Yes, ma'am.
All right. So do you wish to have a jury trial?
Yes, ma'am.
All right. Ms. Ferguson, State, are you all going to be proceeding on the possession 1 to 4 or the injury to child?
The injury child.
All right. So how long is this trial? How long will this trial take? All right. So Ms. Ferguson, if we could set this for a jury trial first thing.
Your Honor, good morning. Frankie Sandoval on behalf of Mr. Saldana.
Mm-hmm.
Your Honor, I have some time this afternoon. Would it be possible for Mr. Saldana to and I to confer just a little bit longer?
Sure.
We'll get the jury trial date, but we have to make sure that we are all on the same page, as it were.
Okay, sure, most definitely.
I appreciate it, Judge. Thank you.
All right.
Your Honor, can I speak on the record?
What do you want to say?
I would like to object to the indictment and the evidence they're using for the indictment, and I'm also reserving all my rights.
Mr. Saldana, why are we talking?
Oh man, I can already smell the smoke as soon as I seen his attorney's tie. Come on, man, get that thing on there right. You got a judge to impress. I'm facing 25 years in prison. But like I said in the intro, this is a very common situation. They're coming in there for trial. He has a 1 to 4, which could be a habitual drug charge, I believe. If he doesn't take the plea deal, then that's going to become an option for the courts. And of course, that dirty paperwork, some kind of abuse to a child. Don't know the background on the case, but when you get to prison, inmates don't care about it. All they see is violence to a child. You're done for. But very commonly, defendants come into the courtroom changing their mind. They want a jury trial. They feel as though their chances taking that route are probably better. And that's the thing, when you're facing decades in prison, you got a bench trial, jury trial, or a plea deal. These 3 options become very hard for defendants to choose, especially when they have no trust in a public defender with a horrible tie. You know, they feel like there's a better route for them, so they come into the courtroom all confused. But the judge is ready, jury trial, let's set it up. If you're to ask me, though, the courts hate this. Ready for trial, they come in and want to change their mind at the last minute. So what's a typical procedure, especially if it's a court-appointed attorney? Pump the brakes. Your Honor, please, just give me a few hours. Let me chat with my client a bit. Maybe we could persuade him to take this plea deal, get this done and over with today. I'm trying to tell you, that's how it goes. It could be a tricky game. Are you willing to risk it for the biscuit or freedom in this case?
Can I speak on the record?
What do you want to say?
I would like to object to the indictment and the evidence they're using for the indictment, and I'm also reserving all my rights.
Mr. Saldana, why are we talking?
All right, so let me explain something to you, Mr. Saldana. I understand what you're saying. I'm internalizing what you're saying.
Yes, ma'am.
But this is what I'm going to say, and I want you to internalize what I'm saying.
Yes, ma'am.
If you need open heart surgery, are you following me with this scenario?
I'm already lost, ma'am.
And the doctor tells you, hey, you need open heart surgery, and I'm going to do the open heart surgery. Do you go to the library, read a book, and tell the doctor, hey, I know you're doing open heart surgery on me, and this is the scalpel you should be using, and this is the stitch you should be using, and this is the way you should perform that surgery?
No, ma'am.
See, and people think that attorneys just talk, oh, I can do that. All they're doing is talking. But behind their talking comes a lot of knowledge and a lot of experience. And everybody thinks that they can do that. So, for example, with regards to an objection to the indictment or objection to the evidence used for the indictment, that's something that your attorney will be taking care of if legally there's a reason for it to be.
How can I ever trust my attorney once again, Your Honor, if he can't even do his tie? Look at him, he's falling apart.
If he determines that legally there's no grounds for it, then he's not going to go forward with it. That's the way it works. So your attorney wants to have a chance to talk with you. I'll let you speak with him in the box. And what date, Ms. Ferguson? All right. Your jury trial is going to be July 2nd. If you want to do something with this case, you can do something with it today, or either what's going to happen is you're going to be set for jury trial on July 2nd.
Yes, ma'am.
All right. Court is calling 2024 CR 2324, State of Texas versus Valentin Saldana. Could I have parties announced for the record for the state?
Marjorie Hillman for the state.
Defense?
Your Honor, good afternoon. Frankie Sandoval on behalf of Mr. Saldana.
Are you Mr. Saldana? Counsel, have you received all the discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Saldana, did you review the document entitled True Bill of Indictment with your attorney, and did you understand it?
No.
All right, you need to speak up.
No.
All right, counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Your Honor, we are waiving the enhancement paragraph, and we're proceeding on the underlying offense.
Any objection?
No objection, Your Honor.
All right, did you review the document entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Ma'am.
Did you understand you're charged with injury to a child, bodily injury intentionally or knowingly? That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. Did you understand?
Yes, ma'am.
All right, you're moving very slow with your answers. All right, do I need to speak up for you?
I think everybody can hear me pretty clearly. Yes, ma'am.
All right. I'm sorry, what?
Yes, ma'am.
Are you understanding everything?
Yes, ma'am.
All right. Did you understand if you have a plea bargain agreement with the state, the court does not have to follow your plea? If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
He has, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
In my opinion, yes, Judge.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Saldana, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
No, ma'am.
All right, do you want to go to a jury trial?
If I'm not satisfied with the way I'm being represented, no, ma'am. I don't want to go to trial.
All right.
So it looks like after a little recess or whatever, the attorney had a chance to talk to his client, and they came up with the right path. No jury trial, he's going to take the plea deal. But he's still not satisfied with him, probably because he still, even after the recess, ain't fix his tie. I would have been like, bro, fix it.
So this is your attorney. This is what I know. We can go off the record. Here's the thing. An attorney will tell you this is what the state is offering you. You can either accept it or reject it. This is a case that the state has made the decision to waive the habitual. If we were proceeding of the habitual, you know what your minimum is?
Ma'am.
What?
25.
And so you're saying you're not satisfied with your attorney when the state is not proceeding on the habitual.
I'm live. Yes, ma'am. I'm live.
What does that mean?
All right.
All right, we're back on the record. Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargain agreement, punishment is to be assessed at 10 years in the prison. There are no applications. The state is taking in consideration County Court Cause number 722472, 2024 CR 3082. There's an affirmative finding of family violence, and there's to be no contact with the complainant. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition? Understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent.
Yes, ma'am.
Did you understand that to be your plea?
Yes, ma'am.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Yes, it is, Your Honor.
Did you review the paragraph entitled Waiver of Appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
There have not, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
Contents.
State, any evidence?
Your Honor, the state offers State's Exhibit number 1 and all attachments.
Any objection?
No objection, Your Honor.
Did you review the document entitled Waiver and Consent to Stipulation of Testimony and Stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
No.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments, and the court will review the same. After reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
In the interest of justice, that would be our request, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, Mr. Saldana presents himself before you, accepting responsibility for the matter before you. As the court may be aware in reviewing his record.
Excuse me, just 1 second. Mr. Cox, if y'all can move down to the other end, we're on the record. That's okay. All right, we're back on the record. Yes.
Thank you, Your Honor. As the court is aware, Mr. Saldana is currently on parole on a previous case. He would respectfully request, and I make this request on his behalf, that although we understand and he understands not binding, we would ask that the sentence that will be imposed today by this honorable court run concurrently with whatever actions parole takes on his former case.
All right, and what are the parole case numbers?
Your Honor,
This guy's still facing years, probably decades for some other crimes. Man, parole violation, I believe is what he said. But he wants it to be ran concurrent when he gets sentenced for those crimes. And if she agrees to that, regardless of how much time he gets today, it's a blessing. You never want it consecutive. That means you're going to have to do time back to back to back. The full amount of time.
if I may have a moment, Your Honor.
Sure.
Thank you. The burglary habitation, Your Honor, case out of the 226 District Court, case number 2014 CR 10282B as in boy.
Mhm.
Yes, Your Honor. That's the open parole matter that, again, Mr. Saldana is aware it's not binding, but he would respectfully request this court make a notation that it's the court's desire that it run concurrent.
All right, this court is going to do. As previously stated, the court is finding you guilty. The court will sentence you to 10 years in the prison, give you credit for any time served. There's an affirmative finding of family violence. This will run concurrent with 2014 CR 10282B. Take in consideration.
Well, there you have it, ladies and gentlemen. 10 years of that man's life is gone. But she did say that she'll write in for consideration for the next judge to run it concurrent. So that's the only victory here, if you were to ask me. Homeboy knew he was going to prison before he walked in there. He just wasn't sure if he was going to fight it or not. And these are the type of mental games that inmates got to think about day in and day out until they get sentenced. Which path are they going to take? Is this one going to get me smoked? Am I being set up? This guy just wants to see me go to prison more than the judge does? You know, all those thoughts are running through your head. And when you start thinking about them too much, sometimes you make the wrong choices. I know a plea deal sounds horrible and a lot of people say never jump on it, but sometimes you do. If it's pretty much an open and shut case, man, you got to take the best cards dealt. Trying to bluff your way to a victory, man, typically 99% of the time ends with you going broke, straight to the penitentiary. That's why it's extremely vital to get yourself a paid attorney. But, you know, people are broke these days. Got to make do with what you got. And that's why I say all the time, man, it's better to take that high road, that square path, because you don't want no judge, prosecutor, or jury having your life in their hands. But I'm out of here, ladies and gentlemen. I got to go cut my grass probably for the last time of the season. Not to mention some major things are going on at the home front. I'm going to break them down here for you soon during a live stream or something. Nothing bad, all good things. Anyway, stay tuned. I got plenty more content coming your way. In the meantime, though, as always, y'all be easy, be safe, and more importantly than anything, stay free.